place of legal pluralism as a legitimate system which can accommodate Islamic family law in Australia is an area of serious contention. And this is arguably a consequence of several commonly held assumptions. For one, it is assumed that there is an increasing demand by Muslim groups for recognizing the Sharia. On the other hand, there exists the assumption of the maltreatment of women in Islamic law. In fact, one of the strongest arguments made against faith-based arbitration by the Canadian government was that Islam in general and Islamic law in particular disadvantages Muslim women by treating them unequally. Additionally, another significant objection to Islamic law or Islamic arbitration in general is the assumption that women could not freely choose to enter into such processes due to the pressure placed upon them. This means that immigrants and refugees who come from either Britain, Canada, Australia, or anywhere in Europe, or are unaware of their legal entitlements in the land that they've migrated to, and so hence assume the law of their religion or else they should either face the law of their religion or else face ostracism, banishment, or any social impingement on their privileges within the nuclear family structure. The problem, however, is that many of these widely held assumptions are largely constructed either on a lack of empirical research or sheer generalizations, which fail to recognize the diversity of interpretations and applications of Islamic law in terms of Muslim women. This does not necessarily exempt the consideration of the rudimentary development of certain interpretations of Islamic law, which are commonly held or even advocated within the Muslim community, nor is this an attempt to be apologetic about the multitude of common beliefs and assumptions which are held within the Muslim community, which may contradict the normative structure of the legal system in Australia. There are many issues related to women and gender within Muslim communities which require addressing, but none of these issues relate directly to Islamic law, but rather to the interpretations of such laws, or the hermeneutics of such laws. Surprisingly, although the general public perception of Muslim countries tend to be negative, and there is a large debate over whether we should adopt legal pluralism or not in the West, it may surprise many of us that many Muslim majority nations remain legally pluralistic. Family law and inheritance matters for Muslims are heard in Sharia courts, but non-Muslims take their cases to the civil courts. The Ottoman Empire, for example, had a millet system which enabled personal law of its different religious denominations to coexist. Muslim Turks were subject to Islamic law, while Christians and Jews followed their own laws, with the heads of their communities officially empowered to exercise jurisdiction over them. So this evening, we wanted to examine whether these commonly held assumptions held any empirical validity. And before we proceed with the Q&A, I'm hoping that some of the ideas that I'm proposing here would stimulate some food for thought. In Professor Crane's well-established work, her world research publication, Islamic Law in Islamic Family Law in Australia, to recognize or not to recognize, Professor Crane separates her work into an opening discussion of the concept of legal pluralism, the international context of Muslims in Australia in terms of the history of Muslims in Australia and methods in which Muslims resolve legal matters such as marriage, divorce, property settlements, as well as dispute resolution. So Professor Crane's study suggests that while Islamic principles are important for Muslims when it comes to specific socio-legal enterprises such as divorce and marriages, other aspects such as property settlement may be understood to operate within the Australian family law setting. Muslims tend to rely on Islamic principles in a variety of ways, through family members, through respected elders in the community, through community organizations and religious leaders, but this should not be held to be understood as if Muslims intend on following their own legal systems, and not to be held accountable under the Australian legal system. In fact, in Professor Crane's research, there is no evidence to suggest that the Muslim community leaders have any desire to set up a separate and parallel legal system, as she had clearly mentioned. Rather, Muslim communities are looking to fit into the existing legal framework and structure. So it seems apparent from Professor Crane's research that many Muslims will choose to go through the various stages of the Islamic marriage process, for example, as well as choose to comply with the requirements of the Marriage Act, thus rendering their marriage valid in both Islamic and Australian laws, respectively. Just as many Muslims would pursue such actions in the case of marriage, it is also found that particularly women finalize their divorces according to both Australian and Islamic laws. And thus, as correctly put forward by Professor Crane in her work, the relevant question should not be whether Sharia or Islamic law should be recognized or accommodated by the Australian legal system, but rather the more important and relevant question is how the Australian family law system or framework can be meant to meet the needs of the Australian Muslim community. So there are many disadvantages and advantages with accepting Islamic law within a pluralistic legal system. Firstly, recognizing a separate system of law or institutions for one religious group could be seen as isolating, differentiating, and separating Muslims from a wider community, thus intensifying what can be called the ghettoization for Muslims. So allowing Muslims to regulate family and inheritance law disputes for a legally recognized entity could also intensify divisions within Australian Muslim communities as well as between Muslims and non-Muslims. Secondly, another food for thought is if a parallel family law system for Muslims was introduced, it may be perceived as obligatory for Muslims, thereby negatively affecting their freedom of choice. So migrants who come from countries where laws of gender equality and family matters are different from Australia may accept a ruling, unaware if they were to go to a family court of the outcome in terms of the divorce, custody or maintenance, the result could have been different. Thirdly, Islam is not monolithic, and this is something where I think we need to emphasize. Islam is different in all parts of the globe. Islam in Somalia is different from Islam in Indonesia. Although the central tenets are shared, there can be considerable variations. So this is also a result of the Sunni Shiite schism, the differences between the schools of Islamic law, political forces, the impact of local customs and practices, the legacy of colonial laws and governance, and more recently the impact of globalization and international law instruments. So today, Islamic law is as diverse as an individual Muslim's allegiance to it. This diversity is important when considering official legal recognition of Islamic law. So whose Islam do we recognize and follow if we had an Islamic legal jurisdiction in Australia? The heart of the matter is that Islam as a legal school has always recognized the diversity of moral, ethical, philosophical, and epistemological concerns of its followers. Scholars of all legal denominations were brought under the scope of Islamic law. Hanafi Islam, Shafi'i Islam, Maliki Islam, Hanbali Islam, and of course the Shiite Jafari Islam. So even within the Shiite Jafari Islam, we find that there are several folds of deductive and inductive methodologies which are employed in deriving sound Islamic sources of law. Each of these schools possess unique and varying methodological techniques in identifying, analyzing, and assessing ethical and social situations using either the deductive or the inductive methods accordingly. Some rejecting logic, some accepting it, so on and so forth. The diversity demonstrates that Islam as a collective set of edicts and precepts make it extremely hard to categorize or generalize Islam under one umbrella. Thus, the challenges with an Australian government accommodating for diverse voices within a community makes the duty to meet the needs of the Australian Muslim community even more difficult. Nonetheless, all schools of thought within the Islamic fold converge within a certain few areas of agreement, the objectives of life, otherwise known in Arabic as maqasid al-Shariah. So those are the preservation of religion, faith, i.e. in Arabic deen, life, nafs, lineage, progeny, nas, or generation, property or wealth, which is known as mal. It would seem that that Australian, as well as any other universal legislation, also aim at protecting one's right to faith, life, lineage, intellect, and property. Perhaps one could also agree that Islamic law ought to be seen just as a brand name of several kinds of alternating laws, aiming at preserving those 5 objectives. Sure, there may be obvious differences emphasized, such as the difference between natural law and divine law, given that Muslims stress that Islamic law is ultimately derived from the supreme deity. Nonetheless, in my personal opinion, the first place where Muslims can themselves work towards managing the multitude normative structures they abide in Australia will be to naturalize divine law. By naturalizing divine law, they can ultimately realize the complementarity which exists between the 2 laws. In this manner, we can also alleviate the negative Islamophobic arguments by making society realize how such laws have more in common if only we could remove the labels imposed on them.